Bismillahir Rahmanir Rahim. We are discussing the topic of Qadhaa or judgment. In this topic, many scholars include the section on Al-Qismah, which is when you divide up a property. This could very well be included in the inheritance chapter because it is linked to inheritance. However, some scholars do mention it under the Qadhaa topic because it is something that the Qadi would decide. So we say that when it comes to Al-Qismah or dividing out the property, then this is of two types. One is called Qismatut Taradi, the Qismah of mutual consent. And so this type of division can only take place if both parties consent to it. And this would normally include one of the parties being given some monetary payment to earn their consent. Then the second type is the Qismatul Ijbar, the forceful division, and here it is not a condition that both parties be consenting parties. So let's talk about the Qismatul Taradi first. This is where if you were to divide up the wealth, let's say a house or a land, then this house or the land or whatever the wealth is so small that if you were to divide it up, it could cause harm to one of the parties who shares in the ownership of this wealth. So because it will lead to a harm, it is likely that one of the parties would not be happy with this division. So to make him happy with this division, you may need to pay him some money. So the point here is that one of the parties will be harmed, and so because he will be harmed, we have to ensure that he is happy with this division. If you have to pay him to make him happy with this division, then this payment takes the ruling of a trade transaction. And in a trade transaction, of course, we know one of the conditions is that both parties must be happy, and it must be through mutual consent. But we come to the question of harm. How do we define harm? The scholars have in fact disagreed on this issue. Some have said harm is that if the property is divided up, then one of the sharers would not be able to benefit from the divided up property. So if we have a piece of land which is shared between two people, one person owns 1/6 of the land, the other person owns 5/6, but they're sharing in this land. So it's one whole land and it's large enough to use. Now if they were to divide this out, so the first person takes his 5/6 and the second person takes his 1/6, so it becomes two separate properties now, then the person who will own 1/6 will not be able to do much on this 1/6 of the total land. He will not be able to build anything on it, and it would be pretty much useless for him. So clearly this division would not bring about any benefit for the second person. Other scholars have said that a darar or a harm is that when you divide up the property, it will lead to a decrease in value of the property. So to compare these two ideas, if we say that the land is 24 meters long, person A owns 5/6 and person B 1/6. If they were to divide it in that ratio, then 1/6 of 24 is 4 meters. On 4 meters of land, person B may not be able to build much, and it would be of no use to him. Whereas on 24 meters of land, you can do much. So, if we say that the darar is when you will not be able to make use of the divided property, then this would be a Qismatut Taradi, because it will harm one of the partners. However, would it decrease the value of the land? Well, let's say the value of the land is £6,000 in total, all 24 meters of it. If he receives 1/6 of it, then the value of that land would be 6,000 divided by 6, which is 1,000. Now this does not decrease the value of the land. In fact, the value of the land has remained the same, proportionately speaking, of course. If, for example, 1/6 of the land would be worth, let's say, £500, then yes, here the value of the land has decreased, because it ought to be worth £1,000, of course. So, if it is worth £1,000, then there is no decrease in the value of the divided property. Hence, this would be a Qismatul Ijbar. So, person B would be forced to accept this division. So you can see, between the two opinions, there's a great difference. It really does make a difference as to whether this Qismah would be a Qismatul Taradi or Qismatul Ijbar. Somebody might say, how can you force me to split up this wealth, where in splitting up this wealth there would be no harm upon me, and there would be no monetary payment given to me? It is more beloved to me to keep this wealth shared as it is, without splitting it. and the other partner is saying, no, I want to split the wealth. So we say to the one who is objecting to the split up, we say to him that if you remained as partners in this wealth, then this partnership will only increase you both in enmity. Because remember, the other partner wants the wealth to be split up, so he does not want to share it with you anymore. So in actual fact, you're forcing him to do something he does not want to do. And the Muslim is a brother of a Muslim. And all Muslims therefore must ensure that they cut off any means to hatred and enmity between themselves. Another example of qismat al-taradi would be if we have a piece of land, but it also has some sort of hills and rocky elements to it. So if you were to divide up the land, you would have a good section, which is a productive section, which you could do things on, and you would have an unproductive section. So the person with the unproductive section is clearly missing out. So if you did want to divide up this land, he would not be happy, and so you would pay him some money to earn his consent. And so this would resemble a trade contract in which mutual consent is a condition. What about the qismatul ijbar? Then this normally pertains to a large amount of wealth. For example, let's just suppose, theoretically, that two people share in a whole village. Now, for us to divide a whole village up into two is not going to cause a great deal of loss or harm to either of the two parties. Or for example, you could have a large garden or a large piece of land, in which if you were to divide it up, it would not cause any harm on either of the two parties. You could say the same thing about a large house, with an equal quality of rooms. It could also be other things, movable things like a bag of rice and meat and other food items. And this type of division is simply a separation of the wealth. It is not a trade transaction, which is what the qismatul taradi is, because you are not giving anyone any money or any payment. And so therefore it does not have any rulings of the trade transaction. For example, it does not have the khiyar al-majlis, which we spoke about, where both parties have the ability and right to annul the trade transaction as long as they have not left each other's immediate vicinity. So in the qismatul ijbar, they can simply divide out the property amongst themselves, or they can appoint an official to carry out the job. So maybe the imam could appoint somebody to carry out the job of the division. Let us shift focus and talk about this idea of making a claim. When you make a claim or a da'wah, it is when you attribute a right or a benefit or a wealth to yourself against someone else. So this is you making a claim. You might be saying that this right or this wealth or this benefit belongs to me, not to someone else. When you attribute a right or a benefit or a wealth for someone else against yourself, then this is an iqrar, an acknowledgement or a confession. And the third category is when you attribute a wealth to somebody against somebody else. And this is a shahada or a testimony. So we have a da'wah, an iqrar, and a shahada. So a benefit could be that a person claims that he rented out an apartment. So this is the benefit of living in an apartment. A wealth could be that he claims that £100, which is in the possession of someone else, belongs to him in fact. Or a right could be that he claims the other person accused him of zina. So this is neither a benefit nor wealth, rather this is a right. And so when you make a claim, you need to provide bayyina, which means evidence. Bayyina is anything which will make the truth bayyin or clear. So anything which clarifies the truth is a bayyina. So it is loosely translated as evidence. So in a case of qasama, let's say, the bayyina would be 50 people taking an oath. Some other times a bayyina could be witnesses testifying to a certain event. So a bayyina sometimes could even be a qarina or an indication to tell us that one party is right and the other one is wrong. For example, with the story of Sulaiman alayhi salam offering to cut the baby in half and give each half to the ladies. So he formed a bayyina here, which is in fact a qarina, an indication that the child belongs to the younger woman and not the older one. So we have a claimant who makes a claim, and then we have a defendant who denies this claim. And both of these two concepts, the claiming and the denying, are only allowed to be done by somebody who is jaizut tasarruf, who has the ability and permission to engage in transactions. What type of person is this? 4 ingredients: baligh, aqil, hur, and rashid. So baligh, he is an adult. Aqil, he's sane as opposed to insane. Hur, that he is free as opposed to a servant. And Rashid, that he is able to spend his money wisely as opposed to being foolish with his money and wasting it. And like we said before, this is one of the conditions of any sales transaction, is that both parties must be jaizut tasarruf. If, let's say, a young child is making a claim, then he does not make the claim. His wali, who is jaizut tasarruf, he makes the claim. As for a servant, then sometimes his claims can be heard. They can be heard in cases where he has a right to make a claim. For example, a servant could be married and he claims divorce, for example. Or maybe he denies a divorce. So both a claim and a denial here, in the case of marriage for a servant, is acceptable. Because here, this servant does own or has the ability to divorce. And this is something he does have possession of, as opposed to his wealth, because his wealth is in fact the possession of his master. What if both parties make a claim to a particular wealth, let us say a laptop computer, and this laptop computer is in the possession of one person. So let's say person A and B make this claim, and the laptop is in possession of person A. Well, if none of them have any bayyinah or any evidence, then the oath is taken by the one whose side is stronger. So the one whose side is stronger is person A, because the laptop is in his possession. So all we would do is we will make person A take an oath that this is his laptop and he keeps it. If the claimant brings evidence and the defendant takes an oath, then who do we give precedence to? We give precedence to the bayyinah. So the oath is only taken in the absence of a bayyinah. If both of them are claiming this laptop and person A and person B both provide evidence that it belongs to each of them respectively, then do we give it to person A or to person B? Remember, the laptop at the moment is in the possession of person A. Some scholars say that if they both provide evidence, then we give it to person B. So in other words, we transfer the possession. They give their justification. They say that the evidence of person B, who currently does not hold possession of the laptop, his evidence gives us an increase in knowledge, whereas the evidence of person A, who currently does hold the laptop, his evidence does not give us an increase in knowledge. So for example, if they both produce their witnesses, then the witnesses of person A will be testifying that this laptop belongs to person A because that's what they've always known it to be. Whereas the witnesses of person B will be testifying that person B, for example, bought this laptop from person A, or perhaps person A gave it to him as a gift. So they will be talking about a transferal of ownership. They will not be talking about the status quo. So in other words, the one who opposes the status quo, he is giving an increase in knowledge. And we go by that which gives us an increase in knowledge. We don't go by that which simply states the status quo. So for example, if the status quo on an item is that it is halal to consume, and we have evidence for that, but then another piece of evidence comes along telling us that it is haram to consume, then the status quo is that it is halal. But if the evidence comes telling us that it is haram to consume, then this is an increase in knowledge because it takes us away from the status quo. Hence we take the increase in knowledge. Other scholars disagree. They say we would have person A take an oath and keep the laptop with him, because in this case they both produce evidence which counteract each other, so we would nullify both of their evidences. It's much like acid and alkali. They come together and they neutralize each other. So when the evidences become neutralized, we have this situation then that person A is the defendant and person B is the claimant, because the laptop is in the possession of person A and this is the status quo, and it is person B who is claiming something which goes against the status quo, thus making him the claimant. And this opinion seems to be more rational, because it is upon us to stick to the asl, unless we have a convincing reason otherwise. Let us now talk about the idea of Shahada, or giving a testimony. And this is in fact a new chapter in Bulugh al-Maram. Al-Hafidh ibn Hajar said, Babu Shahadat. So Shahada is when you're present at an event and you see it firsthand. And technically, a Shahada is when, in a court case, a shahid or a witness comes along and he informs the judge of what he knows. So a shahid is somebody who is present at the event and he sees the event as it unfolds, Sometimes a shahid could mean somebody who shows the way, even if he wasn't there present at the event. For example, in the story of Yusuf alayhi salam, the shahid gave a shahada, saying that if the shirt of Yusuf alayhi salam is ripped from behind, then he is telling the truth and she is lying. If it is ripped from the front, then he is lying and she is telling the truth, despite the fact that this shahid was not there at the event. When Yusuf alayhi salam and the wife of the minister were struggling with each other, and Yusuf alayhi salam was trying to escape her, and she was trying to chase him. But this man is a shahid, not because he was there witnessing the event, but because he is showing people the way. Similarly, of course, when a Muslim gives the shahada of La ilaha illallah wa Muhammadur Rasulullah, he has not seen Allah nor His Messenger, but he gives the shahada. But in our fiqh technical terminology, the shahada is about the person who is present at the event and he sees what happened. Giving a shahada is a serious and grave affair. Lives can be at stake, wealth can be at stake, honor can be at stake. And so the Prophet ﷺ deemed a false testimony to be one of the greatest sins you can commit. So after shirk of Allah Jalla wa Ala, the Prophet mentioned that disobedience to parents and false testimony are amongst the greatest of the major sins. And in fact, he kept on repeating Shahadatul Zur to the companions until the companions were fed up and they wished that would the Prophet stopped saying it. No man must accept the responsibility of being a witness in a court case unless he has seen the event clearly firsthand, about which he has no doubt. Just as clearly as you see the sun. If, for example, this potential witness only has indications which suggest to him what may have happened, he is not allowed to use these indications to testify. Why? Because indications are not good enough. So if you're in a court case and you want to bring forth a witness, you're only allowed to bring forth such a witness who has sure knowledge of what took place. And when this witness actually gives his testimony, which is the ada, actual giving of the testimony, then not only must this person have sure knowledge of what took place, but on top of that, he must also remember what took place. So he saw the event, which gives him the sure knowledge, but not only that, because by the time he gives the testimony, maybe he's forgotten some details. So he must also remember the details of the events as they unfolded. This is not an easy issue. Having knowledge and full remembrance is not easy. If someone asks you to witness a transaction which he is undertaking, then it is fard kifaya upon you to accept. But if you're the only one who could possibly witness this event, then it becomes a fardu ayn. And this is what we call the tahammul, which is when you take the responsibility to witness an event, be it a trade contract or a marriage contract, or whatever the event is. So it could either be fardu kifaya or fardu ayn. As for if you are called to give a testimony in a court case, then you must not refuse. And you are ordered to give your testimony and not to conceal it. And the evidence for this, Allah Jalla wa Ala says, وَلَا يَأْبَ الشُّهَدَاءُ إِذَا مَا دُعُوا. And the witnesses must not refuse when they are called. Likewise, if you have to write down a transaction, the person called upon to write it must not refuse. Allah Jalla wa Ala says, وَلَا يَأْبَ كَاتِبٌ أَن يَكْتُبَ كَمَا عَلَّمَهُ اللَّهُ فَلْيَكْتُبْ. And the writer must not refuse to write down as Allah has taught him, so let him write. So if you are a witness and you take on the responsibility to bring forth your testimony in the court case, so you're going to witness for someone against someone else, when you are brought to the court, it is a fardu ayn upon you to deliver this testimony, because otherwise it means you would be hiding your testimony. And this goes against the Quran. Allah Jalla wa Ala says, وَلَا تَكْتُمُ الشَّهَادَةَ وَمَنْ يَكْتُمْهَا فَإِنَّهُ آثِمٌ قَلْبُهُ. And do not conceal your testimony. Whoever conceals it, then he is of a sinful heart. He says of a sinful heart because your testimony is in your heart. No one knows it except you and Allah Jalla wa Ala. Other scholars are of the opinion that the ada, or when you actually give the testimony in a court, this is not fardu ayn, it is fardu kifaya. So let's take an example to illustrate the difference between the rulings. We have a man, he undertakes a trade transaction and he calls 10 people to witness this transaction. So this is the tahammul. He has asked them to witness the transaction and they all accept. So you have this transaction and 10 people are witnessing it. Then it so happens that he gets into a dispute with his trading party and they take the matter to court. So this man, he has a choice of 10 people. He only needs 2 because in a financial transaction, you need 2 male witnesses. So he could go to any 2 of these. Now the point is this, if he goes to 2 of these people, is it fardu ayn upon both of them to respond to the call and give the adah, which is to actually give the testimony? Some scholars say yes, it is fardu ayn upon them. Other scholars say no, it is fardu kifaya, because here he has a choice from 8 others. But the better opinion here is that if he calls these 2 people to give the testimony in the court, then it is fardu ayn upon them to accept. They must not conceal their testimony. So we say it is fardu ayn on the condition that he is able to give the testimony. If he is unable to, then like with all other obligations, Allah does not burden you with more than you can bear. Also, there must not be any harm upon him, because if he fears that there will be some harm that comes upon him if he gives his testimony, then the obligation is waived. For example, if he gives a testimony against someone else, let's say against person B, and then he fears that person B is going to backbite against him or spread calumnies against him in the community and infringe on his honor, or perhaps person B might destroy his wealth, for example, destroy his shop or his business, or maybe harm his children. In a case like this, neither the tahammul nor the adah is obligatory. So the tahammul is when he takes on the role to witness a transaction, and the adah is when he gives his testimony in a court. Both of these are obligations, but in the case of a genuine fear of this sort, then no, they are not obligations. Likewise, as we said before, but just to repeat, if he is unable to carry out this duty, then again, it is not an obligation upon him. Another condition for the adah or the tahammul to be wajib is that this type of testimony or shahada must be something which is acceptable to the hakim. So for example, the hakim may say that the testimony of a son for his father is unacceptable. Now, if the father is undertaking a trade transaction and he calls upon his son to witness this transaction, so this would be the tahammul, it would not be obligatory upon the son to accept this, because this type of testimony would be unacceptable to the qadi in the court. And likewise, neither would it be obligatory upon the son to give his testimony in the court, because for the same reason, it would be unacceptable to the qadi. Likewise, if a man calls upon a fasiq to witness his trade transaction, it would not be obligatory upon the fasiq to accept this, because the qadi would not accept his testimony in the very first place. Why? Because this man is a fasiq. For example, maybe he drinks alcohol or gambles or the like. So basically, if the qadi would not accept the testimony of this person, then it is not obligatory upon that person to witness the transaction or to give his testimony in the court. Likewise with a kafir, it is not obligatory upon him to accept the testimony, because the qadi would not accept the kafir's testimony in a court. Yes, it is true that the kafir in future may accept Islam, in which case his testimony would be accepted. However, we go by the present, not what could happen in the future. When a witness testifies to a particular property, there's 2 types of possessions that we could have. The witness could say, I testify that this wealth is the possession of Zayd, who bought it from Amr. So this is detailing it out how Zayd obtained the wealth. Or he could just simply say, I testify that this wealth belongs to Zayd, and that's it. So here he has not detailed out how Zayd obtained this piece of wealth. What about if we have a building, let's say a house, and you see that one person is walking in and out of the house and he seems to be looking after the house as if it was his house. Would you testify that this is his house? Some scholars say yes, you would testify that it's his house if he's acting as if it was his house. So he's got the keys to the door, for example, he's walking in and out. Other scholars say no, you do not testify. Rather, you simply testify with what you see. So you simply testify that he has the keys to the door and you see him opening the door, walking in and out, and he seems to have some authority over this house. But you wouldn't testify that he owns the house. And definitely this is the safer opinion. What about a recorded testimony? Are you allowed to play a recorded testimony in a court? Well, we say that if his voice in a tape recorder or a recorded testimony is clear and distinguishable, then yes, it's acceptable, otherwise not. Likewise with a written testimony. So he does not give a verbal testimony, rather he writes out his testimony on a letter, and this is read out in court. If it is verified that this is in fact his writing, then yes, this is acceptable. Just like a wasiyah, when it is left behind in writing, this is something we go by, as long as we know that the person who died wrote this. So in the same way with a testimony. Okay, what about this issue? If somebody gives a testimony of a contract, let's say a marriage contract or a trade contract, then is it a condition that he should lay out in front of the judge the conditions of the marriage contract, such that he should say that this marriage contract took place with the permission of the wali, and both the parties were content and happy, and both parties were eligible to be married, so they were not related to each other, for example, in a way that would prohibit the marriage, and that there were witnesses present. Or for example, if it's a sales contract, that he should mention all the conditions of a sales contract. Well, we say the answer here is no, this is not a condition, and some scholars said that this is a condition. However, we say that the asl on these affairs is that the conditions have been met unless you have evidence otherwise. Likewise, the asl is that there are no preventative factors either. So for example, he does not have to say that this sales contract did not take place after the second adhan of the Yawm al-Jumu'ah, or that this trade contract did not take place in the masjid, because the asl is that the preventative factors are not present. Anyone claims otherwise must provide evidence. You'll remember the hadith of Aisha where she said that there are some people newly converted to Islam, they bring us meat and we do not know if they have mentioned the name of Allah as they slaughtered it or not. And the Prophet said, you mention the name of Allah and eat it. Why? Because the asl is that all the conditions for the action to be correct have been met unless you have firm evidence otherwise. But there could be a case where we strongly feel that the person giving us the testimony is not aware of the conditions. Hence here we would inquire further. For example, a woman comes to us and she tells us that she breastfed both this man and this woman who are about to get married. So in other words, she's telling us that this couple are in fact brothers and sisters through breastfeeding, because she breastfed both of them. However, it seems apparent to us that this woman may not be familiar with the rules of breastfeeding, so she may not be familiar with the fact that the breastfeeding, which creates the hurma, is the one which takes place within the first 2 years of the weaning period, and also it needs to be 5 sucklings, and that this 5 suckling is when the baby puts his mouth to the breast, and then he drinks whatever he wants to, and then he takes the mouth away, and then he puts his mouth back in, so that will be the second one. It could be very well possible that this woman does not know this detail. So in a case like this, we would have to inquire further. Otherwise, we don't need to inquire if we don't have evidence otherwise, or we don't strongly suspect that the person giving a testimony is unaware of the conditions. What about if the witness testifies that one person stole? Well, if this is established, then we would cut off the hand. And because this is the right of Allah Jalla wa Ala, and somebody's hand is at stake, he would have to give in detail how this theft took place. Because as you know, not all types of thefts incur the hand cutting. However, the second element about the theft, in addition to the hand cutting, is that the wealth must be guaranteed, so the wealth must be returned. Now that much we can establish much more easily, that if somebody took the wealth of another, he has to return it, obviously. And the sin is upon the one who took the wealth unlawfully. But when it comes to cutting off the hand, then the conditions are much stricter, and we would have to inquire yet further, because here clearly much is at stake, and the damage which the state would do to the perpetrator, so in this case it's the cutting off the hand, is irreversible. What if a witness testifies that another person drank alcohol or any intoxicant? Yes, this would be enough to establish the punishment. It's true, the one drinking may have been forced, or he may have been ignorant of the ruling. If that's the case, then he can easily put forward his case. But if he doesn't, then we establish the punishment. If a witness is testifying that somebody committed zina, then some scholars say that he has to describe the woman with whom the man committed zina. But we say this is not necessary. As long as it's established that he committed zina, then the punishment is established. But what is obligatory is that he has to mention that penetration occurred. So this is something he has to witness. So even if he saw both of them in bed under a cover or under some sort of blanket, this would not be sufficient for him to testify that the other person has been committing zina. So you can imagine how difficult it would be to get 4 such witnesses who testify to zina. It would be nigh on impossible. And so Ibn Taymiyyah rahimahullah has said that the punishment of zina has only ever been established through confession, never through testimony. Let us take a look at these ahadith of the chapter. 1215 from Zayd ibn Khalid al-Juhani radiyallahu anhu أن النبي صلى الله عليه وسلم قال ألا أخبركم بخير الشهداء هو الذي يأتي بالشهادة قبل أن يسألها رواه مسلم. The Prophet said, should I not inform you of the best of witnesses? He is the one who brings forth his testimony before he is asked it. Muslim reported it. 1216 from Imran ibn Husayn radiyallahu anhu قال رسول الله صلى الله عليه وسلم إن خيركم قرني ثم الذين يلونهم ثم الذين يلونهم ثم يكون قوم يشهدون ولا يستشهدون ويخونون ولا يؤتمنون وينظرون ولا يوفون ويظهر فيهم السمن متفق عليه. The Prophet said, the best of you are my generation, then those who follow them, then those who follow them. Then there would be a people who would give a testimony without being called to do so. They would be treacherous and will not be able to be entrusted with anything. They would take a vow without fulfilling it, and fatness would appear amongst them. We take from the first hadith that the shuhada, the witnesses, are of varying levels, because the Prophet says the best of the witnesses. In the second narration, the Prophet talks about the generations, and which is the best generation. We learn the Prophet's generation is the best, then the one after, and then the one after. So these are the 3 generations. But how would we define a generation though? It appears the best way is not to define it using number of years, but rather the majority of the population. So as Shaykh al-Islam Ibn Taymiyyah says, that the generation of the Sahaba would be as long as most of the people are Sahaba. And then when they die off, most of the people would be the Tabi'een. So that would be the generation of the Tabi'een, when most of the people are Tabi'een. Then afterwards the Taba' Tabi'een would be the generation where most of the people are Taba' Tabi'een in the Arabian Peninsula. So when most of the Sahaba pass away and only a minority are left, then the next generation begins, and so on. So the generation of the Sahaba are better than the following generation. This is generally the case. Otherwise, you could find certain individuals from the Tabi'een who had more knowledge and were more virtuous than some of the Sahaba. You could have a Sahabi who met the Prophet for a very short time. He never learned too much from the Prophet and didn't stay much with him. But then on the other hand, you could have a Tabi'i who is an absolute scholar and a devout worshipper of Allah Jalla wa Ala. So this Tabi'i, from many angles, is superior than that Sahabi. Although having said that, the Sahaba would always have a virtue which nobody else can attain, and this is the Suhbah, or the companionship of the Prophet. When giving a testimony, is it an obligation to use the word Ashhad, or I testify? Some scholars have said yes, it is, but the correct opinion is no, it's not. You can testify however you want to. It's your information which counts, not necessarily the words which you use. But both of these narrations, the first and the second, seem to be opposing each other. The first one talks about the one who brings his testimony without being asked for it being the best of the shuhada, and the second one says that doing so is from the bad traits, because it mentions these people being untrustworthy and these people not fulfilling their vows and fatness appearing amongst them. These are all negative traits. So the Prophet is mentioning negative traits of the latter generations. So how can we reconcile between the two evidences?
Well, there have been some suggestions, but perhaps the best of them is to say that bringing forth your testimony to a court is not to be done unless you are asked to do so, because you do not want to enter somewhere you are not invited. However, the hadith in Muslim praises a person who comes uninvited, quote unquote. And the reason for that would be because this is the type of witness that no one knows about. And so if he does not bring his testimony without being asked, then rights would be lost, because nobody knows that he's a witness, so of course nobody is going to invite him. So we can reconcile it like this. So to put it simply, the hadith in Sahih Muslim is to be understood in a restricted way, whereas the hadith which is muttafaqun alayh, the second one, is to be understood in a general way.
Note something here. In the second narration, the Prophet is informing us of what some of the latter generations would do. He's simply informing us, he's not giving us the ruling on each of these actions. And we need to know that when an information is given, we don't really have the right to extract a ruling of halal and haram, because giving an information is not the same as giving a ruling on that piece of information. So the Prophet here is simply telling us of what will happen. He's not telling us whether it's halal or haram. As for the halal or haram element, then we would have to look at other evidences. So for example, the Prophet has informed us that the ummah of the Muslims would follow those who are before them, handspan by handspan, such that if one of them enters into a hole of a lizard, then one of the Muslim ummah would also follow. The Prophet is talking about following the Jews and the Christians. So the Prophet has not said whether this is halal or haram. He's simply giving a piece of information. Likewise, the hadith in the Bukhari about the woman traveling to the Kaaba on a journey all by herself, without a mahram. Now this does not mean it's halal for a woman to travel without a mahram, but the Prophet is simply informing us of what will happen. He's not turning his attention to whether it is halal or haram. So what about fatness then? Because the Prophet mentions this in this second narration. Well, we say that some people could be naturally fat because they have a slow metabolism rate, and so even if they eat a little amount, they still turn fat. Well, in that case, it's not their fault and they're not taken into account. The blameworthy type of fatness is when you overeat. So it happens through your own actions. That's the blameworthy type. And so likewise with the later generations, we find that the bid'ah increases and people of desires also increase, and the deviant madhahib start to develop. And so, this being understood, it is obligatory upon us to follow this deen the same way that the first three generations would follow it, and to not innovate any new things into this deen which the first generations did not practice. Hadith 1217 from Abdullah ibn Amr radiyallahu anhuma قال رسول الله صلى الله عليه وسلم لا تجوز شهادة خائن ولا خائنة ولا ذي غمر على أخيه ولا تجوز شهادة القانع لأهل البيت رواه أحمد وأبو داود. The Prophet said that the testimony of a treacherous man or woman is impermissible, nor the testimony of someone who has a grudge against his brother, nor the testimony of a servant for his owners. The hadith is Hasan. This hadith is valuable. It tells us about the testimonies which are not accepted. And so from the preventative factors of the Shahada is al-khiyana or treachery. And this is the person who cannot be trusted. Allah Jalla wa Ala says, يا أيها الذين آمنوا لا تخونوا الله والرسول وتخونوا أماناتكم وأنتم تعلمون. O you who believe, do not betray Allah and His Messenger, nor betray your amanat, things entrusted to you, whilst you know. Meaning knowingly. So betraying Allah and His Messenger is when you disobey them or transgress the limits which the Sharia has set. And betraying your amanat is when you have things entrusted to you and you do not return it to the rightful owner. And refusing to accept the testimony of someone who is known to be a liar is something agreed upon by all scholars. The hadith also speaks about someone who has some hatred or a grudge against his brother. So he's not allowed to testify against that person, because he's going to show favoritism against that person. So for example, if two people are known to be enemies, then one cannot give a testimony against the other. The hadith mentions the third category, and this is the servant. So he does not testify for his family he serves, because this type of person would be under suspicion for trying to bring about benefit for his people he serves or ward off a harm, and thereby giving a false testimony. And so similarly, we would refuse the testimony of someone who is known to be fanatical about his particular tribe or his particular people, because if he testifies for them, he is likely to show favoritism and bend and twist his testimony to suit the people he wants to favor.
Also, it is worth knowing that the testimony of a kafir is not accepted, unless it be the case of necessity. Now the Quran makes mention of this. If a Muslim leaves a wasiyah on a journey where there is no one else to witness this apart from a kafir, then that is permissible for a kafir to testify that such and such a person left a wasiyah. But it does not have to be on a journey. It could be any case of necessity. For example, a Muslim is about to die in hospital and he leaves a bequest, and the only person to hear this bequest is a kafir doctor. So can we accept the testimony from a kafir in this case? Well, because it's a case of darura, necessity, we would have to accept the case, and likewise, in all cases of necessity, we may accept the testimony of a kafir. Otherwise, when you make tahammul or call people to witness a transaction, then it must be a Muslim who is adl.
Hadith 1218 from Abu Hurairah. The Prophet ﷺ said, لا تجوز شهادة بدوي على صاحب قرية. رواه Abu Dawud wa Ibn Majah. The testimony of a countryside dweller is not permissible against a city dweller. The hadith is sahih. Normally, between a Badawi and a Hadari, the one who lives in a city, there would be some enmity and hatred. And so because of this, the Prophet has said that a Badawi's testimony is not acceptable against a Hadari. And normally the countryside dwellers would be quite rough in their nature and would not adhere to the laws of the Sharia too much. And so that would lead them to giving a false testimony as well. Most scholars, however, say that it can be accepted as long as this person is a Muslim. And authentically, the Prophet did accept the testimony of a countryside dweller when he said to him that he saw the Hilal of Ramadan, and the Prophet asked him, do you testify to La ilaha illallah? He said yes. And then he said, do you testify that Muhammad is the messenger of Allah? And he said yes. And then the Prophet told Bilal, "O Bilal, announce to the people to fast tomorrow." Although one could still argue against this hadith, because this hadith is not a case of a Badawi testifying against a Hadari. So that would be a different situation entirely. However, we still say that it can be accepted, and that the only reason the Prophet said it's not accepted is because there's normally enmity. However, if we know that there is no enmity between these two people, then what's there to stop us? Nothing. Also, we can say that this hadith could be understood that this Badawi, we don't know if he's trustworthy or not. So if that's the case, then we would not accept his testimony, and that would make sense. However, in the case that we know that the Badawi is trustworthy,
and that there is no enmity between them, then there is nothing to stop us from accepting the testimony, so that justice may be established and rights may not be lost. Okay, let's take some review questions. Question number 1. Give the two types of qisma and explain what they are. Question number 2. What do we do in a case when both disputants provide evidence that a particular wealth belongs to them? Question number 3. We saw in a couple of ahadith there is an apparent contradiction about giving your testimony before you are asked to do so. One says that is a good thing and the other one rebukes the practice. So reconcile between these two narrations.